Okay, looks like we're live. Hi, welcome guys. My name is Dan Brainard with Brainard Realty, and today we're going to talk about the Florida FAR contract, the residential sale and purchase contract known as the FAR. That's going to be our preferred contract that we use here at Brainard Realty. We're going to dive into it today. This is going to be part one of, I believe it's going to be a three-part series of webinars. Today we're just going to get into the content of the contract. We're going to dig right in and find out what it's all about. The second part of the series, or the second module, if you will, we're going to get into all the addenda, the comprehensive riders, and go through all that verbiage and say, okay, well, how does that affect us? And then the final third one, we're going to put it all together. We're going to actually create a contract using our software that we use to house our contracts and our brokerages, Transaction Desk. It's great software. We're going to show you how to put it all together and create a package and actually write an offer, write a contract, send it off to get signed, and show you how to get it electronically signed and back and complete the package so you'll be ready to go. So to start off, there's going to be I'm going to go through the contract today with you, but there's a link, should be down below in the comment box, where you can pull up a copy of the contract and you can scroll through it with me. I highly recommend that to follow along. These forms are also found in either Form Simplicity, which as a licensed realtor you have access to, as well as the previously mentioned Transaction Desk, which is our preferred system of forms delivery. And I'll show you in another webinar why we use that and how that all works. It's really cool stuff. So like I said, today we're just going to be digging down into the content of the contract, what it means, how it affects your business, how you're going to use it to your knowledge of this contract. You're going to use your knowledge of this contract to make your life easier, better serve your clients, better communicate with industry professionals like title people and lenders, etc. And you know, I'm passionate about this stuff. If you know me at all, then you know that this stuff is very, very important to me, that you understand this and you know how to use it, and you got to know it fairly well. Because why? Well, it's simple. It makes you better. It makes you a better agent. Again, better client service, better communication. You protect yourself, you protect me, more importantly. And the biggest thing is you're going to answer a lot of those what if questions that your clients are going to have. What happens if this? What if the buyer does this? What if the seller does this? Guess what? It's all right here in the contract. All we got to do is decipher it. Like it's like Chinese, but we're going to get in there and we're going to knock it out. So a few housekeeping notes before we begin. Just want to let you know this webinar is intended for Brainard Realty agents. However, it's recorded. It's going to be public. So if you're watching it and you find it valuable, great. If you like the content, awesome. Feel free to watch it. It's for entertainment purposes only. I'm not an attorney, so please don't accept this as legal advice. It's not meant to be legal advice. So that said, I'm going to go ahead and share my screen. Hopefully you've got your contract pulled up, and we're going to dig right into this. Okay, so here we are on the FAR contract. So you notice right at the top it talks about the parties. This is the seller, this is the buyer, line 1 and 2. Very important here, the seller. Look at the tax record, make sure the name matches what's on the tax record. If there's a husband and wife, make sure it's got husband and wife on here. If it's a business entity, if it's an LLC, for instance, make sure it's an LLC. Same with the buyers. Your buyers are your buyers. You know who they are. If both the husband and wife want to be on the deed, put both the husband and wife on the contract. If both the husband and wife want their middle initial to be reflected on the deed, on title, use their middle initials in the contract. Maybe just the wife's going to be on the loan and the husband is not. You still want them both on the contract. Very important. Moving right along here, this just says that buyer and seller, buyer agrees to buy, seller agrees to sell based on the following terms. And we're going to just jump right in here. Item 1, this is pretty self-explanatory stuff. It's the property description. Simple address here on top, county. It's going to have the space for the tax ID number. Very important here, there's 3 lines here for the legal description. Now, when you get into these contracts, you're going to see that it's really cool because this stuff gets all auto-populated for you. It's auto-populated for you. So it's going to cut down on your time that it takes to enter this stuff. The thing is, the tax record legal descriptions are entered by human beings. So what you've got to do, what's very important, is that you go, auto-populate this legal description, but you want to find actually a copy of that deed, the warranty deed that's on public record. And in Hillsborough County, they're all online. You can access any one. And make sure that legal description matches. Make sure there wasn't a mistake when it got entered into the system, and it'll save yourself a lot of trouble down the road if you have that situation occur. So that just talks about the property, the actual physical location. D and E sort of deal with, well, actually, let's back up. So the property, and then right here, starting at line 12, together with all existing improvements and fixtures, including appliances, furnishings, carpeting, flooring, any of the flooring, unless it's specifically excluded in the paragraph E below, then it's included in this contract. So anything that's a fixture, okay? Paragraph D, 1D, starts at line 15, talks about personal property. Again, unless excluded in paragraph 1E, E is your exclusion line. So unless it's excluded here, all of the following items are included. Let's go through that. By the way, this is what's included at the property at the time of your initial offer. At the time of the initial offer. So any ranges, ovens, refrigerators, dishwashers, your disposal, your ceiling fans, your intercom, light fixtures. Here's a big one that people always fight about: drapery rods and draperies, blinds and other window treatments. Those are huge. I can't tell you how many times the seller thinks they're entitled to them. My aunt sewed me those custom blinds the day I bought my house. They're mine, I'm taking them. Well, unless they're included in paragraph 1E as an exclusion, guess what, Mr. Seller? Those are supposed to stay with the house. Important we know this kind of stuff. Smoke detectors, garage door openers, security gate, all access devices, storm shutters, etc., etc. Any other personal property included in this purchase are, you want to put that right here in these little line 20 and 21. Anything additional that you don't see there. So one common thing here that you might put here is washer and dryer. If the washer and dryer is coming with the house, you notice it wasn't included up here in paragraph 1D, so you need to include it. Moving on down to paragraph E, these are items that are excluded. So if the seller says, no, the washer and dryer are not part of this deal, they're going to exclude them here, even though they're not technically included. When in doubt, exclude or include. In other words, if it's not listed in the default type up here and there's any question, it's better to mark it, include it or exclude it, so that you eliminate any gray area. Okay, good. Moving on. Purchase price and closing. This is important because this line right here pretty much determines how much you make on the deal, your commission. So we all know why that's important on the purchase price, but that's where you're going to enter right here on line 26. This is going to be the total purchase price. So if it's the first offer you're writing and you're giving to a seller, this is going to be your initial offer price. It likely will change. Very rarely does the first offer get accepted unless it's been maybe verbally accepted ahead of time, but most often this is going to get changed. So if you put in 200,000 here, for instance, and you submit that, when you get it returned, it's going to have a big X in it, and then or cross, strike through, and then it's going to have a new price, 215,000, let's say, with a little initial next to it. That's our counter. So any changes that the seller is going to make on your original offer, they're going to strike through, and they're going to make the changes, and they'll have to initial it, and then your buyer would have to initial it, and vice versa if you're representing the seller. So the line below that, line 27, this is where your escrow deposit goes. The amount of escrow. Your escrow is a good faith estimate from the buyer, demonstrating that they will do their best effort to perform their obligations under this contract. A good rule of thumb, although there's no rule that it has to be, but a good rule of thumb that I like to use is 1% of the purchase price or $1,000, whichever is higher, the greater of those two numbers. So if the house is $50,000, 1% of that's only $500. So you probably want to bump that up to $1,000 just to show that they're serious. The higher the escrow deposit, the more attractive the offer will be to the seller, and vice versa. I've had clients put $100 here and they got away with it. I was shocked. You can put anything in that number, but just know that you have a better chance of getting your offer accepted the higher and the more significant that amount is. Unless the check is with the contract, you're delivering it in person, either the check to the title company or the check along with the contract to the seller or the listing agent, then you'll check this box number 2 here under line 29. So the escrow deposit is delivered to the escrow agent within blank amount of days. The default is 3 after effective date. So you can put 2, 3, you can put 5 if you want, but just make sure that you have the escrow delivered to the escrow agent within that amount of days, within X amount of days of the execution date. Under here, 32 through 34, you're going to put the escrow agent information. This can be a title company that you have a relationship with that could possibly transfer it over later if the seller chooses a different title company, or you might find out who the seller intends to use ahead of time and just go ahead and put it down there to begin with. Additional deposit. Sometimes after you clear inspections, for instance, you might add additional deposit into escrow. So this line 35, you'll put how many days after execution would be the deadline. If you leave it blank, it's 10. And then here you put the amount. On item C, line 38, this is talking about financing. You're going to put either a dollar or a percentage, a dollar figure or a percentage. So if it's a conventional standard 80-20 loan, in other words, they're getting 80% financing, you would put 80% here. Or if you wanted to put a figure, let's say your offer was 200,000, you would put, geez, math, let's go. What is that? 160,000, right? So that's what we'll go there. Other would be if there's some other kind of compensation. If you're going to throw in the buyer's horse for some reason or whatever, that would go there. Some other kind of compensation. And then finally, on line E would be your balance to close. So that should be the purchase price minus the rest of this stuff will equal this number here on line 40. Okay, simple enough. Moving right along. This is pretty easy stuff here. Time for acceptance and counteroffers. Very important here. And it talks about effective date. If not signed by buyer and seller, an executed copy delivered to all parties on or before. Oops. You can have a little drop down here where you can choose the date. Then this offer shall be deemed withdrawn, and the deposit, if any, shall be returned to buyer. Unless otherwise stated, time for acceptance of any counter offer shall be within 2 days after the day the counter offer is delivered. So 2 days is a default time for acceptance of a counter offer. I get that question a lot. How long do they have to answer? How long do we have to answer a counter offer? Well, you have 2 days per the contract. Part B, the effective date. This is very, 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 very crucial here, guys. The effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed and delivered this offer or final counteroffer. So it's not just when they sign it, it's when they deliver it. So if your buyer or your seller is the last person to sign off on something and you have a copy of that and you are out somewhere away from your computer and you cannot send it until the next day when you email it, even though your client might have signed it yesterday, when you deliver it today, that is your effective date. So, and delivered. Closing date, this is pretty self-explanatory. You can choose it. You can, if you're using transaction desk, you just hit a drop down, boom. Very convenient. You put your closing date in there. Don't think I need to go into too much on that. Extension of closing. The Consumer and Financial Protection Bureau has done a wonderful thing. They've increased the period of time that it takes us to get our contracts closed by way of merging a few different closing procedures relating to title and lender responsibilities. Anyways, short story long, this part A deals with that. So let's say everything is in place, but these rules, because they have to have certain documents out in a certain number of days before closing, otherwise they cannot close on the closing date, it might get delayed. This automatically, this rule here, this 5A, extends the closing date for up to a maximum of 10 days automatically if it's delayed as a result of these CFPB requirements, or the tried requirements. So that's that. Part B of this extension of closing date deals with natural disasters, force majeure. So hurricanes, winds, terrorism, I believe, was included recently. Terrorism, looking for terrorism. I think it may be later on in the contract. But anyways, it is included. But if something happens, a natural disaster or some kind of act that prevents the closing because, for instance, utilities aren't on its title company or whatever, this contract gives you until 3 days. You have up to 3 days after the restoration of those utilities to close. Thereafter. So I personally thank God I've never had to deal with this, but it's there in case we need it. Item 6, occupancy and possession. Part A says, unless Part 6B is checked, which is not for this purpose, then the seller shall at closing deliver the property to the buyer free of tenants, occupants, and future tenancies. So no leases can be in place unless this 6B is checked. Also at closing, the seller shall remove all their stuff. Get your crap out of there. Take all your personal items, your trash, property, everything, and give the keys to the buyer, give the garage door openers, give the remote controls to the ceiling fans, whatever you got. Give it, the keys to the clubhouse, the keys to the mailbox, give it to the buyer on closing. If occupancy is delivered before closing, to be delivered before closing. So if the buyer is going to actually move in before closing, the buyer assumes all risks of loss to the property from the date of occupancy and shall be responsible and liable for maintenance from that date on. So if the buyer moves in early, come closing date, they can't go to the seller and say, hey, these walls, there's some scratches on these walls that weren't there. Sorry, you accepted that already. And it should be deemed that they've accepted the property in its existing condition. So that's that. Now, 6B. This is very important, especially if you deal with investors or people that are buying rental property, buying or selling rental properties. 6B, if the property is subject to a lease or occupancy after closing, you have to check this box, because what that does is, when you purchase a property, or when somebody purchases a property, if there's a lease in place that extends, let's say, for instance, 6 months after closing, the new buyer has to honor that lease by law. So this box right here, when you check it, that basically gives the buyer, if they're going to have to honor this lease, that could be 6 months, 5 years, who knows? If they're going to have to honor this lease, they should at least have the opportunity to take a look at it and review it as part of their due diligence before they are committed to purchasing the property. That's what this paragraph talks about. The seller has 5 days after effective date to deliver all the lease information or any other information as mentioned here in this paragraph. So that's that. Assignability. There's 3 options here. I hate this first option, but we'll read it out loud anyway. I wish they would strike it. Buyer may assign and thereby be released from any further liability under this contract. The buyer may assign this contract, so the buyer may assign all his obligations or her obligations under this contract to someone else and be released from any further liability under this contract. Well, that doesn't sound very good if you're a seller, for instance. Shoot, or if you're the buyer's agent. The second one here is may assign but not be released from liability under this contract. Well, that sounds a little bit more reasonable. And the final one is may not assign this contract. That's probably going to be the one you're going to use most often for your normal buyer. This second box here, may assign but not be released from, we use that a lot if you have, for instance, an investor who writes a contract under his personal or her personal name and then decides they may want to open up a business entity, an LLC, for instance, and take title in the LLC. And they want to do that. They just don't have it open yet. So they might want to hold on to the right to assign it to that LLC so that they can close in the LLC's name while they create it during the escrow period. And that's usually not a problem. Okay, this is huge. Financing. This is probably one of the most important sections here. There are options for how is the buyer going to pay for the property. So option A is cash. Buyer will pay cash for the purchase of the property at closing. So this is kind of interesting because you're selecting cash, the buyer's going to pay cash. They're still allowed to get a loan if they so choose, if they fit the rest of their obligations through the contract. So they're not required to pay cash. However, they're not afforded any of the protections that a normal financing contingency would allow. So those the Consumer and Financial Protection Bureau requirements that extend the date up to 10 days if the loan's not ready to close, those are not in play here if the buyer selects A and still tries to get a loan. So just very important to know. Item B, this is the most common one. This is the contract is contingent upon financing, some type of financing. So starting on page 93, it's contingent upon financing, and it's contingent upon the buyer obtaining a written loan commitment. And then we talk about, we're going to fill in some blanks here to determine what kind of loan terms the buyer is seeking. So is it conventional? Is it FHA? Is it VA? Or is it some other? Perhaps it might be USDA, which is like a rural loan, or maybe some portion of seller financing. Who knows? So there's an other box for you if it doesn't fit into the other main three. So it's going to be that type of loan. It's contingent on that type of loan. We're on line 94 here, and it's going to be on the following terms. Within, they want this loan commitment within, and this is, if left blank, it's 45 days. 45 days after effective date. That's the loan commitment date. So it's contingent upon them getting a loan commitment, a written loan commitment after 45 days or within 45 days based on these terms. And then it can be a fixed rate, it can be an adjustable rate, it can be a fixed or adjustable rate. You can put a maximum interest rate if you don't want to expose them to the possibility of them having to take a predatory type loan at 10%, for instance, right now. As the date of this webinar, the 10% is extremely high for a traditional loan. If left blank, the prevailing rate based upon the buyer's credit rating. So if you don't fill out this percentage right here, they could be obligated to take that 10% loan if that's the only one they qualify for, if you don't cap that. So maybe a conversation you might want to have with your buyer. So, and the final part of this is for a term of, and if it's left blank, it's 30 years, okay? This next component here, line 99 through 103, just deals with when they have to make, when the borrower has to actually make their loan application, because they've got some deadlines here, and talks about some of the stuff with the loan commitment. So the buyer should make the loan application within 5 days. That's the default. Don't let your buyers drag their feet on the loan application. It can only hurt the team. Okay, don't let them drag their feet. They have the opportunity to shop around if they want to talk to a few different mortgage lenders, but they need to do it quickly. They should already have their documents. They should have already been pre-approved. So they should have an idea who they're going to go with, I would think. And you really need to get the official loan application going so that it doesn't delay closing or the rest of their obligation under the contract. So because they're promising right here on line 100 to make a good faith and diligent effort to obtain a written loan commitment within the time period and then close. So you also, in this paragraph, the buyer is authorizing, is saying that we're going to keep the buyer, we're going to keep the seller and the broker fully informed of the mortgage status, the loan application status, and the loan commitment status. And we authorize the buyer's mortgage broker and buyer's lender to disclose such updates, such status updates with the seller and with the broker. So that's a big thing right there. So as a listing agent, that means you are perfectly within your rights to reach out and contact the buyer's lender to ask for a update on their financing. Upon buyer's receipt, this is line 104 here, upon buyer's receipt of loan commitment, the buyer shall provide written notice to the seller. If the buyer does not receive a loan commitment by the loan commitment date, then either party may cancel the contract. Either party may cancel the contract at that point, up and until one of these two things happens. 1 and 2. So either up and until buyer delivers a written notice to seller that the buyer has either received loan commitment or elected to waive the financing contingency. So they've either received the loan commitment or they've said, I'm pretty sure I don't need it still. I'm pretty sure this loan's solid and I don't even care. I'm just going to waive my financing contingency. So one of those two things can happen. Or once you hit within 7 days of closing, then the buyer has lost their opportunity to cancel the contract and still receive their escrow money back. Up until those two, if neither of those two things have happened, either party can cancel with written notice. Escrow is returned. Everyone goes on their merry way. No harm, no foul, except the realtors have to start all over again. That's about it. So if either party timely cancels, that's basically what I just said here, then yeah, they get their money back. Everyone goes on their way. That's what I just said. Okay, great. Line 115. If buyer delivers written loan commitment to the seller and then they don't close, and the reason they don't close is due to one of the following, either seller, and it doesn't close, then the deposit will be paid to the seller. So the buyer, if they give the loan commitment to the seller and they fail to close, they're forfeiting their escrow to the seller, unless it's due to one of these following things: seller default, property-related conditions of the loan commitment have not been met. For example, the lender says their appraiser mentioned a lot of termite damage or termite signs, and the seller agreed to do the termite repairs but never did, and now they can't get the loan because of it. That would fall under that property-related conditions. Number 3, the appraisal of the property was not sufficient to meet the terms of the loan commitment. So if the appraisal comes in low, even after the loan commitment, this is, a lot of people probably don't know this. A lot of very experienced agents probably would not know this little fact, that even after a loan commitment, a low appraisal can still cancel the deal and the buyer would be entitled to their escrow back. So as long as it's not within 7 days of closing, a low appraisal is always a deal killer, and you can never keep the escrow, basically, unless you know this and the other agent doesn't. So, which a lot don't. Anyways, moving on. If the buyer's lender goes belly up and they don't have money to fund, that would be the last one. So that's all under financing. Those are all financing. That's a whole financing contingency right there. You remember we had cash, and then that was all financing, and then we had these little 2 other options. Assumption of existing mortgage, that's if the buyer wants to take over the mortgage of the current owner. And then the final one is a seller financing, the purchase money note and mortgage to seller. So if the seller wants to become the buyer's lender, so to speak. Okay, good. Moving right along. Let's talk about the closing costs and fees and charges. So 9A is typical seller costs. 9B is typical buyer costs. And you can read all these doc stamps on the deed is the seller's obligation. The owner's title policy and charges is usually paid by the seller here in Hillsborough County. Title search charges, municipal lien search, HOA condo estoppel fees. That's HOA Condominium Association estoppel fees are basically fees that the HOA charges to provide, payoff information so that everybody knows what is owed via the HOA at closing date. Recording and other fees needed to cure the title. Seller's attorney's fees, other. That would be if just anything random, you're able to fill something in there. Now, this is where the contract, there's 2 versions of this contract. This is the full one. We also have an as-is, which is a little bit shorter. This full one, we have some repair limits here. And basically the way these things work is there's 3 different repair limits. One is for general repairs. One is for WDO, which is wood destroying organisms or termites. And one is for closing out expired or open permits. There are 3 separate allowances. So let's just say, for instance, that you have $1,000 each for these. And the general repairs, the actual repairs come out to $3,000. But there's no needed repairs for the WDO or for the permits. However, the buyer has a $1,000 allowance built into the contract. The seller is not obligated to take those other 2 sets of $1,000 allowances and apply it to the $3,000 worth of damage under the general repair. They're separate entities. That's what I'm trying to explain here. So you can either do it as a percentage of the sales price or a straight dollar figure. Okay, but if the repairs that qualify under the general repair items, and we'll go over those in a second, if the amount of those repairs falls within the amount of this allowance, The buyer can't cancel and neither can the seller. Both parties are obligated to see it through. And if it's $1,000, the seller has to spend the $1,000 to fix it and the buyer can't cancel. With the other contract, which is an as-is contract, neither one of those are true. So the buyer can just say, you know what, I didn't think there was as much damage as there ended up being. I want to cancel. Or the seller can say, you know, I'm not spending a stinking cent because this is as is. And both are within their rights to do so. So typically there's a little bit of a meeting of the minds with those other kinds of contracts where there might be a little bit of back and forth as far as what the seller might be willing to do, but nobody is obligated, which is the main difference here. So here's another big part right here. A lot of times you'll go through the transaction, you get the repairs done. Let's say you're representing the buyer. The seller was supposed to do the repairs or do other stuff, whatever. You get to a day before the walkthrough or the day of closing at your walkthrough, and you go through, lo and behold, the repairs that were supposed to be done were not completed properly, or they weren't completed at all, or there's new damage or what have you. This paragraph starting on 139 addresses that situation. I was in the business probably 2 years before I ever read this paragraph, and I probably dropped the ball a handful of times by not knowing this. So let's go ahead and take the time to read that. If prior to closing, seller is unable to meet the maintenance requirements as required by paragraph 11, which is later on, we'll find out what paragraph 11 says. This layout is kind of weird, but nevertheless, if they're not able to meet the requirements of the repairs, replacements, treatments, or permitting as required by paragraph 12, then sums equal to 125% of the estimated cost to complete the applicable items, but not in excess of applicable general repair, WDO repair, or permit limits set forth above. So basically, 125% of the estimated cost to fix those issues, as long as it's not higher than the original limits, shall be escrowed at closing. Shall be escrowed at closing. So they're supposed to put that money aside at closing, and then if the actual cost to get those items corrected exceed that escrow amount, the seller is supposed to pay the difference in actual cost. Again, not to exceed those repair limits. Okay, so basically, if they don't handle this on their own, it's supposed to be escrowed. Okay, and there's a similar clause in the as-is regarding the as-is maintenance requirement of that contract. So any unused portion of those escrows amount would be returned to the seller. Okay, so those are seller costs. Costs paid by buyer. Taxes and recording fees on the notes and the mortgages. So not on the deed, but on the notes and the mortgages. Recording fees for the deed and financing statement. So the buyer is going to record the new deed that's in their name, and they're also going to record their mortgage. They got to pay for those fees to record them. An owner's policy and charges if 9C2 is checked, and we're not there yet, so we'll show you how that works too. A survey, generally going to be required by the lender. A lender's title policy. So notice up here on 9A 128, the seller pays for the owner's title policy and charges here in Hillsborough County, but the buyer down here on B on line 151, the buyer pays for the lender's title policy and endorsements. There's two title insurance policies. One is for the owner, the new owner, and one is for the new owner's lender. That's if there's financing. If it's cash, there won't be a lender's policy. Transfer fees for HOA, loan expenses, that's some of your closing costs that related to your loan. Appraisal fees, you can have an appraisal. Inspections, attorney's fees if that's applicable, and all insurance, property insurance would be cost for the buyer. It's important to be familiar with that when the buyer asks you, well, what am I responsible for? Or the seller asks you, what am I responsible for? Well, it's pretty clear. That's what you're responsible for. Those are some standard costs right there. 9C, title evidence. So the big thing here is that the seller is to deliver a title commitment. In other words, a letter laying out the conditions by which the closing agent will, or the closing title agent will be able to issue a title policy. So they're supposed to issue that if it's a cash deal, or if it's a financing deal, they're supposed to issue that at least 15 days. You see right here, 15 days prior to the closing date. If it's cashed, If it's a cash deal, or if 8A, remember 8A is the cash component, then it's 5 days. So just something to remember. If the seller already has an owner's policy, they're supposed to deliver it to the title company and to the buyer within 5 days as well, within 5 days of execution date. Within 5 days of execution or effective date, they're supposed to issue that. Once you receive that, whether it's the loan commitment, or once you receive the title commitment, whether it's 15 days or 5 days, once the buyer receives that, they have 5 days to review it and make any, raise any issues with it. If they don't agree with something, or if they're not going to be able to accept it, they're supposed to respond within 5 days. This talks about line 162 and 161 and 162 talks about who pays for title, how that's handled, and it's all basically determined by, down here in this next page, 166 through through 178. So let's take a look at that. So if this box is checked here, 166 item 1, the seller designates the closing agent and pays for the owner's policy and charges, and the buyer shall pay for the premium for buyer's lender's policy and charges for closing services related to the lender's policy. So there's endorsements and loan closing. Those amounts are paid by the buyer to the closing agent or such other providers. So the seller pays for owner's policy, the buyer pays for lender policy. Item 2, if you want to check this, doesn't make a lot of sense a lot of times, but the buyer will designate the closing agent. That means they choose, instead of up here the seller choose, seller picks, seller pays. Line 2, the buyer chooses and designates the closing agent. So in this case, if they do this, they're also paying for their owner's policy. So now they're paying for their owner's policy and their lender's policy. So again, you would see why it wouldn't make a lot of sense most often to choose that if you had the buyer, or for the buyer. A survey, this gives the buyer the right to order a survey. The lender's going to require it. If the seller already has a survey, they're supposed to submit that to the closing agent and to the buyer within 5 days after effective date. Number E is a home warranty. The contract says either the buyer can pay for it, you can ask the seller to pay for it, you can say, no, we don't need one. You would put in the name of the company here on line 183, and also the cost over here. Typically, they probably average anywhere from $400 to $700, depending on the size of the house. Obviously larger for larger houses. Line F, special assessments. These are not relating to, and you can see in parentheses, not relating to condominium or HOA associations, who are the usual suspects when it comes to levying assessments. This paragraph is discussing basically municipal type assessments, something that by a public body, okay, by a public body. So that'd be city, county, things like that, but not HOA. So this doesn't have anything to do with HOA special assessments or condominium special assessments. So very important to remember that. But what this basically says is, if there are any special assessments levied by those public bodies, down here it says either A, the seller is going to pay the installments due prior to closing, and then the buyer will pick up the tab after closing. Or section B, which is if you have the buyer, hint, hint, you're always going to want to select this one. The seller shall pay the assessments in full prior to or at the time of closing. So if neither box is checked, then option A is deemed selected. Okay. This is very important right here, line 196. Again, this does not apply. This is what's great. I'm just learning this now because I learn something new every time I read this. But this paragraph does not apply to a tax lien imposed by a CDD, or a community development district, a CDD. So even if CDDs are levying special assessments, those are still not included here in this paragraph. So okay, we're getting down to some general disclosures here. Radon gas, the essential thing here is that radon gas is naturally occurring. and it can present health risks if overexposed to it. Homes are more and more energy efficient these days, less and less air leak, and so therefore the naturally occurring radon gas can accumulate more in some newer homes. So that's important to be cognizant of. Permit disclosure. This is basically saying that the seller, other than what they've already disclosed, doesn't know of any issues with permitting, essentially, or they don't know of any non-permitted construction. Although I can't think of anybody that's ever admitted to non-permitted construction. However, I still see it all the time. So somebody's not always being honest with these. Anyhow, moving on. Mold. You guys know what mold is. It's Florida. It's everywhere. If your buyer's afraid of mold or fears mold in the house, they should have it tested by the appropriate bodies. Flood zone elevation certificate. If the borrower cannot get flood insurance within a certain amount, within 20 days of the effective date, the buyer can be refunded the deposit and cancel the contract. It's essentially what this big thing says. An energy brochure. We offer that in our packages. In fact, we have the buyer sign off on an energy brochure package. So it says, buyer acknowledged the receipt of this. So we make sure that they initial it. So they do it here and they initial it in the package. And you'll see that on another module. Lead-based paint. This is very common, especially if you're working in larger cities with older structures. Anything built before 1978, you have to have a lead-based paint disclosure. It's mandatory. If the home was built in 1978, it is my interpretation that you do not need a lead-based paint disclosure. However, when in doubt, err on a side of caution. So if you're not sure, you don't think you're comfortable with the language, then include it for 1978. I personally don't. 1977 or earlier, you'll need that. HOA disclosure. If there's an HOA community, it says that buyers should not execute the contract until they've received and read the homeowners association disclosure. That's a disclosure to the buyer. Property tax disclosure summary. This basically says don't rely on the current tax amount to project what your future taxes on the property will be. They'll use the current amount to prorate at closing. However, anytime a property changes hands, it triggers a reassessment of the property, and therefore there could be significant differences in the amount of taxes owed. One person might own the house for 15 years prior with a homestead exemption in place, which also comes with a nice feature where the amount that their taxes can raise, that their assessment of value can raise, is capped. So for 15 years, they might have risen very, very slowly. And then all of a sudden, boom, it's going to reset and your buyer is going to be paying twice as much in taxes. So that just discloses that to them. FIRPTA tax withholding. I am not going to lie, I do not know very much about FIRPTA. This is if you have a foreign seller, if you are someone that is going to be working a lot with foreign sellers, I highly recommend that you research this a little bit more. To my understanding, if I have a foreign seller, I'm going to get their tax person involved and get them connected with the title company right away so that they can meet any of these tax withholding requirements. But it's really not something that I am extremely familiar with. Seller's disclosure. This just says that the seller has disclosed everything that they know about the property that materially affects the value of the home, which is not readily observable. So if you walk into a house and you see that the ceiling has caved in and it's very clear, that's not something that has to necessarily be disclosed because it's readily observable. However, if the reason that the ceiling is caved in is because of a small leak or a large leak somewhere in the attic and in the roof that the seller knows about that perhaps you can't see, that is something that would need to be disclosed. So when in doubt, you should always recommend that your seller disclose. Okay, property maintenance and condition. This is some of that stuff that was referenced earlier in the contract. Property maintenance, except for ordinary wear and tear, and those repairs and replacements and treatments that were required by the contract that we talked about earlier, the seller shall maintain the property, including but not limited to the lawn, the shrubbery, the pool, in the condition it existed as of the effective date. So if the pool was nice and blue with the fountain on, it needs to be nice and blue with the fountain on at closing date. If it's green with tadpoles, snakes, and whatever else in there, then we have a problem and we need to address it as a buyer's agent. Number 12, property inspection and repairs. Inspection period, the buyer shall have blank. If it's default, it's 15 days. 15 days. I like a 15-day inspection period as a buyer's agent because the more time you have to inspect, the better. The better it is for your buyer. The worse it is for the seller. I like to personally leave this thing blank because if I fill it in here, especially because I like to use this blue ink, when I fill it in my opinion, if I have the buyer, it's going to draw attention to the fact that we want 15 days. And it's, in my opinion, and it's just anecdotal, I don't have any empirical evidence, but I think it's more likely that the seller sees that and the agent sees that and they cross that out and they put 10 days or some other smaller number there. When I've left it blank, I've had more success with it not getting changed at all. I don't know if it's psychology, I don't know what the reason is, but I think maybe something might to do with new agent. If it's just not called their attention, they just think it's type form and just they glaze right over it and no big deal. 15 days, that's the default, that's the norm, when in actuality 15 days is a really healthy inspection period, especially for a home that's not necessarily, if it's not, a 5,000 square foot home, 15 days is really a nice amount of time to get it inspected. So that's my take on that. You can do what you like, but the default is 15 days there. That 15 days is after effective date. So the buyer can inspect for the general, the WDO, and permits within that time period. And if they don't make any report or any request for those repairs, it's deemed that within that time period, it's deemed that they have waived their inspection period. Okay. If the buyer causes damage due to their inspections, if they suspect Chinese drywall and they drill through the drywall to test it, and then they don't end up closing, they are required to go back and repair that drywall. They take these big chunks of drywall out for it. So they're required to go back there and repair that stuff or any other inspection that causes damage. Here we get down into general property inspection and repair. So this is real good stuff here because it defines what are considered general repairs, what are warranted repairs, what are acceptable, basically under the general repair allowance. What repairs fall into that category, which ones don't. So this line B1 here on line 60, it just says basically you got to have a professional inspector, someone that knows what they're talking about. You can't have cousin Vinny come in and look at it, or Melissa Tomei come in and inspect with her wrench and whatnot. You've got to have a licensed professional do this, okay? Item 2 here is the property condition. So this talks about what is covered. What is it supposed to be? It's supposed to be, the following items are supposed to be free of leaks, water damage, structural damage, and then those items are the ceiling, okay, the roof, including the fascia and the soffits, the exterior and interior walls, the doors, windows, and the foundation. Those should all be free of leaks, water, and water damage and structural damage. Those items, together with the pool equipment, major appliances that are owned, heating and cooling systems, mechanical systems, electrical systems, security systems, sprinkler systems, septic and plumbing systems, and machinery, seawalls and dockage shall all be maintained until closing in a working condition. So that's defined below. What is working condition? So it continues on. Torn screens, including pool and patio screens, flood windows, and missing roof tiles or shingles should be repaired or replaced by seller prior to closing. Seller is not required to repair or replace cosmetic conditions defined below. So unless the cosmetic conditions resulted from a defect in an item that the seller is obligated to repair or replace. So here's that definition for working condition. Working condition means operating in the manner in which the item was designed to operate. Cosmetic conditions means aesthetic imperfections that do not affect working condition of the item, including but not limited to pitted marcite, tears, worn spots, and discoloration of floor coverings, wallpapers, window treatments, nail holes, scrapes, scratches, dents, chips, caulking and ceilings, walls, flooring, tile, fixtures, or mirrors, mirror cracks in walls, floor tiles, windows, driveways, sidewalks, pool decks, and garage and patio floors. Cracked roof tiles, curling or worn shingles, or limited roof life shall not be considered defects seller must repair or replace. So just because the roof is old doesn't mean it needs to be replaced or repaired. If it's working properly, according to the terms of this, the definitions here, then it's working properly. There's nothing that needs to be done to it. So long as there's no evidence of actual leaks, leakages, or structural damage. Okay, so just because you don't like the paint color, just because the baby drew a crown on the paint on the side of the wall, or just because there's a scratch, or they scratch something moving out, those are cosmetic. Those are not generally general repair items. So it says the general property repairs, the seller is only obligated to make such general repairs that are necessary to bring those items into the condition specified above. So the seller just has to make them work properly according to the contract. He doesn't have to replace them necessarily. Okay. Within 10 days after receipt of buyer's written notice for general inspection report, the seller shall either have the reported repairs estimated by an approximate licensed person and a copy delivered to buyer, or have a second inspection made by a professional inspector and provide a copy to the buyer. If the buyer and seller's inspection reports differ, the parties cannot resolve the differences. They're supposed to get together and choose and split the cost of a third inspector, whose report will be binding. That'll be the decision maker. So that's how you handle any disagreements there. Now, this next part is going to be very similar to the rest of the other categories. So wood destroying organisms or inspection closeout of permit. So I'm not going to read all those, but I'll read this paragraph here. This talks about what happens if the repairs cost more than the allowance. And this is the same for each of the categories of allowances. So if the cost to repair the items is equal to or less than the general repair limit, the seller shall have repairs made in accordance with above. If the cost to repair those items exceeds the repair limit, then within 5 days after receipt of the last estimate, the seller may either A, elect to pay the excess by delivering written notice to buyer, or the buyer may deliver written notice to seller designating which repairs of the general repairs seller shall make at a cost not to exceed the general repair limit, and agreeing to accept the balance of general repair items in their as-is condition, subject to seller's continuing maintenance requirements. So that's saying the buyer can say, well, I had all these repair requests. It's way outside of what the repair limit is, but let me just show you the most important ones, and these are the ones that will fit under the repair items. I'm good with those, and I'll take care of the rest of the stuff on my own. So those are the two options there. And then the third thing is if neither party delivers the written notice, then either party may terminate the contract, and the buyer shall be refunded the deposit, and everybody is released from the contract. Same thing with the wood destroying organisms. Same thing with the same basic stuff with the permits. So moving right along, after you get through all the repairs and you're through appraisals, hooray, comes the walkthrough. On the day the walkthrough, you can go the day before or the day of is recommended. And the buyer's representative can do it. I highly don't recommend that you do it on your own in lieu of your buyer or in place of your buyer. It can only hurt the team. So you can do the walkthrough just to confirm that the personal property is still there and that the property has been maintained and that the repairs have been done. Repair standard and assignment of repair and treatment contracts. So repairs shall be completed in a good and workmanlike manner. So this is kind of a gray area, by appropriately licensed person in accordance with all requirements of law. So you can't have, again, Cousin Vinny fixing whatever the item is, unless Cousin Vinny is licensed and or qualified in some way, shape, or form to do that. So where are we? If the repair should consist of materials or items of quality value capacity and performance comparable to or better than the existing as of the effective date. So you can't just, if there's a sink that needs to be replaced, you can't replace a nice sink with a little metal sink or whatever. So you get the idea. Okay. So escrow agent and broker. So any closing agent or escrow agent receiving the deposit is authorized and agrees authorized and agrees by acceptance of them to deposit them promptly. So they got to put them in an account. They got to hold it in escrow, set it to collection. So, and then disperse them in accordance with the terms and conditions of this contract. So failure, funds become collected shall not excuse buyer's performance. So just because the buyer doesn't place escrow doesn't mean they don't. If a buyer goes under contract and they don't put escrow within that first 3 days, and they don't properly still cancel the contract, they can still be in default of the contract, and they could still be required to owe that escrow deposit. That's what that says. This just talks about what the closing agent is supposed to do if they're in doubt of conflicting demands on a deposit. So there's some stuff that has to go on there. They file an interpleader with the court, which basically will try to remove them from the argument, and then the court would take over the funds that have been collected, the funds that are in escrow, and determine who's at fault. And then this also does say that they would go through mediation. The agent's going to recover the attorney's fees, so the closing agent's going to take closing fees out of the money that's collected to cover their cost of that interpleader, and then this paragraph survives closings. So this really deals with how the title company, how the closing agent would address any disputes or conflicting claims over any escrow money or things of that nature. Professional advice and broker liability. Okay, this is advising the buyer and the seller to verify the property conditions, square footage, and other facts, representations made within this contract, and to consult professionals for legal, tax, environmental, and other specialized advice concerning matters affecting the property and the transaction contemplated by this contract. Broker represents the buyer that broker does not reside on the property, and that all representations, oral, written, or otherwise, by broker are based on seller representation or public records. Buyer agrees to rely solely on their, it's in bold print, buyer agrees to rely solely on seller, professional inspectors, and governmental agencies for verification of property conditions, square footage, and facts that materially affect the value, and not the representations of the broker. So this is basically holding the broker harmless. Okay, this is saying we're here to help you find the property. It's your job to inspect and make sure that it's satisfactory to you. Buyer and seller individually, each individually indemnifies and holds harmless and releases broker and broker's officers, directors, agents, and employees from all liability for loss or damage, including all costs and expenses and reasonable attorney's fees at all levels suffered or incurred by broker and broker's officers, directors, agents, and employees in connection with or arising from claims, demands, or causes of action instituted by buyer or seller based on 1, inaccuracy of information provided by the identifying party or from public records, 2, identifying party's misstatement or failure to perform contractual obligations, or 3, broker's performance at identifying party's request of any task beyond the scope of services regulated by Chapter 475 as amended, including broker's referral, recommendation, or retention of any vendor or on behalf of identifying party, products or services provided by any such vendor or for or on behalf of identifying party, or what is this? Shoot, what is that, a 5? V, expenses incurred by any such vendor. So, buyer and seller each assumes full responsibility for selecting and compensating their respective vendors and paying their other costs under this contract. So what does this basically say? This basically says if the buyer or the seller relies on the agent to help find them contractors or inspectors or title companies or surveyors or whoever it is, that they're holding us harmless for their performance, and if anything comes out of that, they're holding us harmless for those kinds of things, those kinds of recommendations. In other words, it's ultimately up to them to search and hire those professionals. We might do it as a service to them, but we are held harmless from anything that comes out of that. Basically, as long as you are not negligent or malicious, you're mainly protected here. Although we want to still do the very best job in representing our clients. Default. A talks about buyer default. The buyer fails or neglects or refuses to perform buyer's obligations under this contract, including payment of the deposit within the time specified. Seller may elect to recover and retain the deposit for the account of seller as agreed upon liquidated damages. Consideration for execution of this contract and in full settlement of any claims whereupon buyer and seller shall be relieved from all further obligations under this contract or seller. Seller's options may, pursuant to paragraph 16, proceed in equity to enforce seller's rights under this contract. So here's an interesting point. The portion of the deposit, if any, paid to listing broker upon default by buyer shall be split equally between listing broker and cooperating broker, provided, however, cooperating broker's share shall not be greater than the commission amount listing broker had agreed to pay to cooperating broker. So what does that mean? In the listing agreements, there is an option for the seller and the listing broker to agree to share any proceeds that are collected as liquidated damages, i.e. escrow deposits. Some might be 50%, some might be less, some might be more. Whatever the damages that are shared with the listing broker, the listing agent, this paragraph says that those damages should be split 50-50 between whatever the listing broker gets paid for that. The selling broker is supposed to split 50-50. They're supposed to get 50% of that. I found that interesting. I didn't know that for a few years until I read this thing. So seller default, if for any reason other than failure to seller to make seller's title marketable after reasonable diligent effort, seller fails, neglects, or refuses to perform seller's obligation under this contract, buyer may elect to receive return of buyer's deposit without thereby waiving any action for damages resulting from seller's breach, and pursuant to paragraph 16, may seek to recover such damages or seek specific performance. Seek specific performance. Seeking specific performance. You will undoubtedly at one point in your career, if you haven't already, get asked by your buyer, well, what happens if they just don't close, if they just decide to change their mind and they don't sell me the house? Well, unfortunately, the answer is that they can sue for seeking specific performance. So the cost to do that is going to be so high that it would very rarely ever be a reasonable thing to do. So unfortunately, sometimes it just is what it is. And at the end of the day, there may not be a whole lot of recourse if the buyer doesn't, or if the seller does in fact change their mind, unfortunately. But that would be technically their course of action would be to sue for and seek specific performance. This paragraph, by the way, 15, it survives closing and or the termination of this contract. So that's that. Dispute resolutions, unresolved controversy and claims between the buyer and seller. They're supposed to go to, within 10 days, present conflicting demands on the deposit. Then they're supposed to submit that to mediation back to under paragraph 16b, which is right below here. So buyer and seller attempt to settle disputes in an amicable manner through mediation, pursuant to point acquired mediators, yada. Mediator must be certified, must have experience in the real estate industry. Disputes not settled pursuant to the paragraph 16 may be resolved by instituting action in the appropriate court having jurisdiction of the matter. This one shall survive closing as well. Attorney's fees. If the parties will split equally the mediation fee incurred, and each party will pay their own costs and fees, including attorney's fees incurred in conducting the mediation. In any litigation permitted by this contract, the prevailing party shall be entitled to recover from the non-prevailing party costs and fees, including reasonable attorney's fees incurred in conducting the litigation. So again, this one survives termination, but that basically says if it gets past mediation and we go to litigate, then the loser has to pay the winner the attorney fees, in a nutshell. Okay. Standards. I know, guys, hang with me. We're about 10% of the way through. No, I'm just kidding. We're cruising right along here. We'll get through this real quickly here. Title evidence, restrictions, easements, and limitations. This is basically the title commitment is going to set forth any issues with title that need to be cleared, that show restrictions, and the title commitment is going to set forth the matters. You see right here, those matters that should be discharged by the seller at or before closing, and to provide that upon recording of the deed to the buyer, an owner's policy of title insurance and the amount of the purchase price shall be issued to buyer, ensuring buyer's marketable title to the real property, subject only to the following matters. So, comprehensive land use plans, zoning, and other land use restrictions, prohibitions and requirements imposed by government authorities, restrictions and matters appearing to the plat or otherwise common to the subdivision, outstanding oil, gas, or mineral rights of record without right of entry, unplatted public utility easements of record, and no more than and some stuff about utility easements. This is basically just saying the exceptions that your owner's title policy wouldn't cover. Moving right down here to title examination. Again, I mentioned this earlier. The buyer has 5 days after receipt of title commitment to examine it and notify the seller in writing of any defects that render the title unmarketable. Survey. If the survey discloses encroachments, easements or land use or violating restrictions, covenants, or applicable government regulations described in Standard A, then the buyer shall deliver written notice of such matters together with a copy of the survey to seller within 5 days after buyer's receipt of survey, but no later than closing. If buyer timely delivered such notice and survey to seller, such matters identified in the notice and survey shall constitute a title defect subject to cure obligations of Standard A. If seller has delivered a prior survey, seller shall at buyer's request execute an affidavit of no charge to the real property since the preparation of such prior survey to the extent the affirmations therein are true and correct. Ingress and egress. The seller represents that there is a way in and a way out of the real property, and that the ingress and egress is insurable according to Standard A. Lease information. The seller shall, within 10 days prior to closing, furnish to buyer an estoppel letter from tenants, occupants, especially on the nature and duration of the occupancy. Basically, this is a letter to make sure that all the collected fees and everything are properly handled and everything is squared away at closing regarding any lease hold tendencies that are on the property. Lien, seller's going to furnish a closing affidavit attesting to the absence of any financing statement, claims of lien, or potential lieners known to the seller that are or have been that there have been no improvements or repairs to the property for 90 days immediately preceding closing dates. This is the title company's, the closing agent is going to do their lien search, and this is an affidavit by the seller to the buyer stating that they had not done anything in that interim to encumber the property, because if the title company, if something were to come, a lien were to get recorded between the time that the title company got their loan, their title commitment and the time of closing, potentially a lien could come onto the property. And so this is the seller signing an affidavit saying that he hasn't done anything to encumber that. Time. Here's a big one, guys. Time, F501. Highlight it. Calendar days shall be used in computing time periods. Calendar days, not business days, calendar days. Time is of the essence in the contract. Other than time for acceptance and effective date, any time periods provided for and dates specified in this contract, so whether they put an exact date or whether they put 10 days after such and such, doesn't matter. Any of those dates that end or occur on a Saturday, Sunday, or national holiday shall extend to 5 p.m. The next business day. 5 p.m. the next business day. So an acceptance date or a time for acceptance could be Christmas Day, and it would not get pushed to the next day. It could be Christmas Day. Same thing with an effective date. Other than time for acceptance and effective date, any other time periods, including closing date, per this standard here, if it falls on a Saturday, Sunday, or a national legal holiday, it goes to the next business day at 5 p.m. So if your inspection period is set to expire on a Saturday, you have until 5 o'clock on Monday, the following Monday, if it's not a legal holiday. So very important when you're calculating your days and everything like that. So, a 5 or 6 day inspection period that starts on a Monday is going to end up going to, a 5 day inspection period that starts on a Monday goes through to the next Monday. It's almost like a 7 day. So very important to understand how that works. Force majeure. There we go. There's my acts of terrorism included here as what is considered in force majeure, or acts of nature, I guess. Acts of God and acts of insurrections, wars, and terrorism. So, conveyance. On H, seller shall convey marketable title to the real property by either statutory warranty, a trustee's personal representatives, or a guardian's deed as appropriate to the status of seller. So, subject only to matters described in Standard A. So, subject only to those title standards that were Standard A. So, So this is just saying that the seller is going to convey that title, that marketable title, by way of statutory warranty deed to the buyer. So they're going to sign over a deed of sale. Closing location, documents, procedures, location. Closing shall take place in the county where the real property is located. Documents, seller is going to, at or prior to closing, execute and deliver as applicable a deed, bill of sale, certificates of title, or other documents necessary to transfer title to the property. Construction lien affidavits, we just talked about that. Owner's possession and no lien affidavits, and assignments of leases. Seller shall provide buyer with paid receipts for all work done on the property pursuant to the contract. Buyer shall furnish and pay for, as applicable, the survey, flood elevation certificate, and documents required by buyer's lender. Okay, procedure. The deed shall be recorded upon collection of all closing funds. The deed gets recorded in public records. We talked about that earlier. That's where you can go and find the actual legal description if it's in public records. If the title commitment provides insurance against adverse matters, I would have to revisit that to understand that. but we'll move along. You can revisit it as well. Escrow closing procedure. This talks about where the escrow is going to be held, and their procedures for doing that and depositing those funds. Prorations and credits. This deals mostly with taxes and prepaid items. This talks about how they get levied up and how they get counted and accounted for at closing. Access to property, conduct appraisals, inspections, and walk through. The seller needs to, upon reasonable notice, provide utilities service and access to property for appraisals and inspections, including the walkthrough. When you're dealing with bank-owned properties, a lot of times they don't have the utilities on, and a lot of times they have an amendment or an addendum that overrides this whole contract, and it'll say that they're not going to have utilities on. But in general, the seller should have utilities on for inspections. Here's some information about what happens if the property's risk of loss, if it's after effective date, if there's a fire or something like that. It talks about how that's handled. 1031 exchange is something that's important. If you have investor clients, it's important that they know about it. You might learn a little bit about it as well, but it basically allows them to enter and exit out of different real estate transactions without having to pay the capital gains tax or as much taxes if they structure it and do it properly via the 1031 exchange. Talk to your title person about that if it's something that your client is interested in. This contract is not recordable in public records. This talks about the people that are bound. It's bound on, I believe, parties and their respective heirs or successors. Okay. Notice. Basically, this says that notices must be in writing and made by mail or electronic media, including PDFs or email. A fax or electronic copy of this contract, and any signatures herein shall be considered for all purposes as an original. Here's one I like. This contract may be executed by use of electronic signatures as determined by Florida's Electronic Signature Act and other applicable laws. So we talk about notice and delivery is given by or to the attorney or broker, including such brokers' real estate licensees, representing any party shall be as effective as if given by or to that party. So when you send an email with an offer, that is just like the seller or your buyer, whoever your client is, sending it. So that's considered notice. And you send that to another person's agent, that is notice, just as if they sent the buyer directly, send it to the seller and vice versa. Integration and modification. There's nothing else outside of this agreement. This is the whole contract, nothing but the contract, and et cetera, et cetera. Waiver, failure of buyer sell. So waiver, this clause says that just because we don't enforce a certain aspect of the contract or take advantage of any right under the contract, it does not constitute a waiver of other provisions or rights. So if I let one thing slide on this contract, I can still enforce another. Okay. Writers, addenda, and typewritten or handwritten provisions shall control all printed provisions of this contract and conflict with them. Next, collection, talk about what is collected. It's basically when it clears their account and escrow agent. Loan commitment means a statement by the lender setting forth the terms and conditions upon which the lender is willing to make a particular mortgage loan to a particular borrower. Neither a pre-approval letter nor a pre-qualification letter shall be deemed a loan commitment for purposes of this contract. This just says this needs to be applicable law and venue. It would be Florida under the state Florida laws, and you would go through the appropriate avenues for resolution with mediation, arbitration, litigation. Shall lie in the county where the property is located. So we talked about some of that stuff. Here's some more stuff about FERPTA. Again, it's very long, but get that with your people, with your get the tax person with the title people and let them do their thing. Okay, we've reached sort of the end here. These addenda and additional terms, we're going to have a whole nother webinar where we're going to go through all of those and the verbiage, but that's basically it. Oh, down here, it's very important. Additional terms, this is where you would type something in. Quite often what you'll see here is something about closing costs if you're asking for closing costs. So it's very important when you're asking for closing costs. I recommend putting a dollar amount that you want. I don't recommend putting a percentage of a purchase price. But if you do put a percentage of a purchase price as a requested seller disclosure, please make sure you include the term purchase price. So you would put something like this. Seller to contribute 3%. Here's what you wouldn't want to do. Or let's see, seller to that is not what you want to put. Seller to pay 3% closing costs. If somebody's closing costs are $8,000, 3% of $8,000 is whatever, I don't know, but it's not what you think it's supposed to be. So right here, what you're asking for is probably closer to something to $6,000. So when you ask for 3% closing costs, you're asking for 3% of the total closing costs, which is not very much. So you'd want to say 3% of the purchase price. Toward buyer's closing costs. Okay, whatever, you get the idea. So I would just prefer you put $6,000, but you can say seller to pay 3%, but make sure you put purchase price. And then the other thing is, the very end here, I find that agents rarely do this, where they'll check this box: seller rejects buyer's offer, or seller counters buyer's offer. Usually they'll just either email it or they'll just mark it up and then sign it. They rarely ever check one of these boxes, but technically that's what they're supposed to do. What else? This is a legally binding contract. If you do not fully understand it, seek the advice of an attorney. So that's disclosing to your buyers that they should have an attorney if they don't understand what they're signing. Here's where they would all sign and date. Here's the buyer's address. Oh, down here at the bottom, here's where you would put your name as the sales associate, and then your brokerage, what you put here. And then what they're saying now is that they want you to put your license number up here. Something like that, and then they when you put your brokerage license, your broker's license down here as well next to the broker name. That's to help them with the new closing disclosures and everything that they're supposed to be doing. So just a little heads up, I'll probably set up the packages so that when you pre-fill it, it might have that in there for you. I don't know, I got to look into that. But anyways, that is the FAR/BAR contract. Congratulate yourselves. Give yourselves a round of applause, a pat on the back, have a glass of wine. You knocked that out. You crushed it. And if you have any questions, leave them in the comment box, or if you're an agent of mine, you know how to reach me. So, all right, talk to you later. Thanks.